Good afternoon. How are you today? Well, we're getting a blessing today. We got about 72 degrees now. Boy, am I going to be spoiled. The cold is just around the corner. We have the darkness to go with it at the end of the day. So, what should we be talking about? Well, I'd like to focus on something that just won't leave us alone, and that is these subpoenas that the Select Committee on the January 6th insurrection issued. And Flynn is among this number. We have Bannon floating out there. He was held in contempt and nothing's happened to him yet. God bless you, Garland. Wake up and do something, or explain to us why you're ignoring the efforts to bring down our government. Some would think that that's something a law enforcement officer should be looking at. So we have these people, and this group hasn't yet told us, I suppose, they're going to appear or not appear, and some may appear, and that will answer part of the question. But I wonder what Flynn's going to do, huh? You think that's a big question mark? So early December is when they're supposed to appear. Let me take you back to those crazy days when I was a young prosecutor, pup prosecutor, and I was in what we called the junk unit, which was prosecuting narcotics cases. And in that day, I was not prosecuting a case at trial, but I was in my office when somebody came to me and said that in the ongoing narcotics trial, conspiracy trial that was going on, that the defendant in the case had apparently reached out for a juror, and his attorney had reported that he'd seen something suspicious happen, and he reported it to the judge. Now, this person was a former prosecutor, and he did the right thing, and I didn't think he had done anything wrong, certainly not of a criminal nature. And some might argue he didn't have to say anything at all to the judge, but he did. So when the case was over, I was assigned a jury tampering investigation of that trial, and the guy was convicted. So I went to the defense attorney, and I asked him to tell me what happened. And just as he told the judge, he told me what happened. And it certainly appeared that there was evidence of jury tampering. So then I said, I want to put you before the grand jury to say that. And he said, well, I don't really want to do that. And I said, well, why is that? He didn't want to look like he was, cooperating, I guess is the word. And I said, well, I can give you a subpoena. Then you'd be compelled to appear. And you're not volunteering to appear. You're plainly being asked to appear under penalty of contempt. So I said, oh, okay, that's good. He was okay with that at first. And so I set a date for him to appear before the grand jury. And I said, I'm going to ask you what goes on. So in the grand jury, when we got there, he refused to answer the questions. And so I asked him all the questions that I could. And then I said, we're going to go down to the judge and have you held in contempt. And so we did. And the federal judge, we're talking about the same day that in the grand jury, he refused to answer the questions. I went down before the judge and I asked, I said he won't testify before the grand jury. It was then a sealed proceeding, but all of this became public because of what I'll tell you. And I asked the judge to order him to testify, and the judge did, and he refused. So I asked the judge to hold him in contempt, and the judge held him in contempt. And he said, well, I want a stay, an opportunity to appeal it. And I said, if he seeks an expedited appeal within the next week, then he doesn't have to be in custody. But if he fails to do so, then he should be in custody. And I thought that was a fair compromise. And I thought the issue was pretty clear. So he submitted a brief. I submitted a brief. We argued it before 3 judges in the U.S. Court of Appeals for the Second Circuit. How long did all of this take? A couple of weeks. And at the end of it, the judges entered an order that basically said he had to testify, And the reason was he couldn't use the attorney-client privilege. There were third parties involved, but he couldn't use it anyhow to conceal a crime by his client. Not that he wanted to do that, but that was certainly the only way you could look at it. Now, you might wonder if I could do this without getting scuffed shoes myself. Well, AUSAs came to me and they said, why do you have to do this? And a high-level person in the office, not the U.S. attorney, did as well. And I said, are you telling me not to put him in the grand jury in this jury tampering investigation? And everybody said no. And at one point, I was with another senior official that had a high regard for me, as I did for him. And I said, well, I'm going to have some trouble getting a position when I leave this office. And I could tell by the look on his face that my joke was true. And there was some difficulty, but I had a decent reputation as a litigator, and I ended up at a firm that was founded by FDR Jr. with some of the best lawyers I've ever known in my life, my whole life. So what's the moral here? The moral is it doesn't take long to bring on a contempt proceeding and to enforce it in court. So you have to ask yourself, what the hell is our Attorney General doing? And the answer is nothing. He's not doing anything. It seems to me he's doing a slow walk, hoping what? It'll go away by Christmas, by Thanksgiving, over the next break of the Congress. That's not acceptable. Now, if I'm on the committee that is looking into the insurrection, what do? I don't go to the Attorney General if I have to hold any of these other witnesses in contempt. I go with the inherent power that the Congress has to go after those witnesses who refuse to cooperate individually, arrest them, put them in the basement. In fact, I've been looking for an architect because I want to make an announcement with an architect for the most beautiful jail that we could install in the basement of the Capitol so that no one had any excuse. But there are rooms all over DC that can be used and accommodate the jailed existence of Flynn or Bannon or any of these people. And that's what we should do, because our entire notion of law and the Constitution is at risk. And that means our democracy is at risk. And this is what we've got to do. We have to address the problem. We can't ignore the problem. And part of the problem is Garland, as I've said for days, as many of you are entirely pissed off about. Not that I'm saying it, but that what he's not doing. And we have to consider the fact that maybe he feels he can do this because Biden hasn't spoken to say, get on this. And that's what he should be saying. We're going to repeat what we did wrong in Virginia. Oh, it's nothing. It'll pass. We can deal with it in this way. Well, in the campaign for governor, they dealt with it by ignoring the issues that were getting a toehold in Virginia that gave margins to the guy who's now about to become the governor, the Republican. And if we're not careful, we're going to find ourselves behind the 8 ball when these guys run away with the next demonstration that perhaps brings even more people to their side to overthrow the government. You think this is a fiction? No, sir. And madam, because if you're going to say there's no consequence for defying the law, then there's no consequence for defying the law. They'll do whatever the hell they want. So that's my thinking today. Hope you're having a good day, and I'll talk to you tomorrow. Bye-bye.